Did you know that small and medium-sized enterprises represent 99% of all businesses in the EU and account for 70% of all jobs? Close to 45% of GDP in the EU was generated by IPR-intensive industries. SMEs are the motor of the EU economy. Their potential to boost employment and drive future innovation, two key priorities for the European Union, should not be overlooked. SMEs are particularly present in innovative industries such as clean technologies, healthcare, ICT, etc. Today, more and more SMEs are looking for business opportunities in emerging markets. Many of those companies are considering China, Southeast Asia, and Latin America as potential destinations. Trade relations between the EU and emerging markets have taken a new turn with the ongoing negotiation of FTAs and investment agreements. These regions are attractive destinations for European investors, with their fast-growing markets, rising middle classes, and competitiveness. Due to limited resources and available capacity, SMEs face many difficulties in managing their IP assets, and particularly when this involves IPR infringement in other regions. Intangible assets such as intellectual property rights are key factors in the competitiveness of businesses in the global economy. We have to be aware that IPR-intensive industries contributed 86% of imports and 93% of exports to EU external trade. And in developing markets such as Southeast Asia, Latin American countries and China, your trademark, patent, trade secret, industrial design are endangered. Before internationalizing your business, take an active part in protecting your assets. The International IPR SME Helpdesks are here to assist you and contribute to SMEs' internationalization by the provision of step-by-step advice to build a successful IPR strategy for entering into the Chinese, Southeast Asian and/or Latin American markets. The range of services offered by the Helpdesk includes a 24-hour helpline service to reply to IPR questions, free online and on-site trainings delivered by IPR experts, free publications on various IPR topics and country fact sheets, and other useful information forms such as case studies, e-learning modules, video podcasts, and more. So if you have any inquiries on IP protection, contact the Helpdesk in China, SEA, or Latin America to learn how to manage your IP assets and expand your business successfully.
Okay, I have the cue to start. May I kindly request for all participants to settle down, and we shall begin our webinar now. Good afternoon. Well, rather good evening to everybody. Mr. Francesco Floris, Head of Trade and Economics EU Delegation to Malaysia, representatives from Southeast Asia IP SME Helpdesk, Nora Bihari and team. Welcome, Mr. Sven Schneider, CEO EuroCham Malaysia, esteemed bilateral chambers, business associates, distinguished guests, ladies and gentlemen. Welcome to the session to EuroCham's Advocacy Talk series today. Our discussion this afternoon, again, this evening, is titled New Trademark Updates in Malaysia. We are delighted to have two expert speakers from our IPR sector, Dr. Chris Hemingway and Encik Azrul Abdul Hamid. And we are honored, excuse me, and would like to thank you both for making the time today. On top of that, we would like to express our gratitude to you for continuously assisting the Chamber's Working Group Sector Committee pertaining all IPR related topics, seminars, market access meetings, and events together with our esteemed team from Southeast Asia IP SME Helpdesk and the EU Delegation to Malaysia. And for today, we will be listening in for an in-depth discussion on key cases in IPR areas like what is now protected under the new Trademark Acts, TMA, and how to get registrations under the TMA, and what is an infringement and how does one enforce one's rights under the TMA. So we will be hearing more from our expert speakers in a couple of minutes, and as usual from the Chamber's desk, I am Dida and will be facilitating the webinar for today. Now let's go through the agenda quickly. We will start off with Mr. Sven Schneider to say a few words, followed by a brief welcome note by our Head of Trade and Economics Relations, the EU Delegation to Malaysia, Mr. Francesco Floris. And then we move on to the highlights of the webinar presentation by Dr. Chris Hemingway and J. Mohammed Azrul. And last but not least, we will follow through with the final segment, which is the Q&A session. And next, before we start, a few housekeeping rules we all have to adhere to. This webinar will take approximately 60 minutes, and the session will be recorded and will be on live stream shared on EuroCham's Facebook page. Secondly, may I request for all panelists to keep your microphones on mute unless you are presenting. For attendees, I may highlight that you're already automatically muted. And however, should you have any questions concerning the topic, of course, please write them down in the Q&A box at the bottom of your screen, and we'll get the experts, speakers to address them all together at the end of the session. Now, without any further ado, I would like to invite Mr. Sven Schneider to give his welcome remarks. Sven, the floor is yours.
Thank you, Dita, and I will keep it rather short because we have our experts with us today, so it's best they speak a little more than I do. But I would say, first of all, thank you and welcome to everybody to the webinar. It's great to see that with the pandemic being more controllable, at least it feels like that, and we are now getting back to real topics, technical topics, and are not firefighting every day. That's a blessing, I would say, and I'm glad that today we are collaborating with our colleagues from the Southeast Asia IP SME Helpdesk. I'm glad that we have with us Chris and Azrul, because they are really the experts, and they're also part of our IPR sector committee. So they will speak to you about all the latest in regard to the trademark updates here in Malaysia. From the chamber, we are looking forward to a series on the IP topic, and I think in collaboration with the IP SME Helpdesk. And I would also like to thank you lastly, but not least, Francesco Floris from the EU Delegation for being with us. He will say a few words right after this, I believe, and then we will come to the presentations by our speakers. And with that, Data, I shall conclude. Thank you so much.
All right, thank you, Sven. Okay, thank you. And to Francesco Floris, maybe an opening remark or a little short welcome note for the audience. Francesco, the floor is all yours.
Yes, thank you very much. Good evening, everybody. Thank you for inviting me to this event. We, as European Union, are happy to support the Southeast Asia IP SME Helpdesk and EuroCham and the Intellectual Property Sectoral Committee of EuroCham. So trademarks or brands are basically a sign, the expert will tell you better than I can do. They are a sign that distinguishes basically the goods of one company from those of another. And therefore, it's very important because it is associated with the perception that consumers have about the quality and the health and safety of a product. So it also triggers research and innovations by company to always be on top of their competitors, leading to improvements and overall also benefit for consumers and for employees. In the EU, we saw the initial presentation, the video, the intellectual property intensive industries constitute 45% of the GDP and 39% of EU employment. On average, wages are 40% higher in IP intensive industries. And also we saw the numbers about imports and exports associated with high intensive IP. So it's really important to protect trademarks to avoid that competitors use the name of somebody else to sell products. It's not only about decreasing the sales of genuine companies, but it's also about health and security of the consumers, because we are not only talking about luxury goods, textile and clothes, but also any other goods, including pharmaceuticals, medical devices, personal protective equipment. And this is unfortunately counterfeit is a phenomenon which has always been there, but it has increased even further with the development of electronic commerce, e-commerce. So strong provisions to let's say prohibit and punish counterfeit is of utmost importance. We also saw the numbers at the very beginning about the volume of fake products, which are every year sales in the EU, not only produced in the EU, but also imported by other countries, including in particular China. So all this is to say that this is a particularly important event, and we look forward to hear from the experts all about it. Thank you very much, and have a nice seminar.
All right, thank you, Francesco, for sharing some important IPR insights from the EU delegation perspective. Thank you very much. And now, this brings us to the highlight for this session, introducing our first speaker, Dr. Chris Hemingway, who is also the director for Marks and Clerk Malaysia's in Berhad, and which is the largest specialist international firm of patent and trademark attorneys in the world. He specializes in the drafting and prosecution of patent applications and is one of the only a few practitioners in the country who are also qualified as UK European patent attorneys. Dr. Chris has experience with a broad range of technical subject matter ranging from mechanical and software-based inventions to medical devices and chemical innovations. In more detail, he has particular expertise with security and communication software, artificial intelligence, AI, banknote validators, and other fintech, broadcast data receivers, electronic toys, play equipment for children, trigger sprayers, power tools, and pharmaceutical drugs. He holds a PhD in microbiology from the University of Warwick and gained a number of years of valuable commercial experience in industry in the fields of IT and biotechnology prior to joining the legal profession. And we cannot wait to hear from you, Dr. Chris, to give us an overview on this topic. And the floor is yours now, Dr. Chris.
Thank you, Data, and Sven and Francesco. Let me just see if I can share the slides here. Okay, hopefully that is working. Oh, hang on. Okay, I think that's working. Yes, today we're going to be talking about trademarks. I'm going to look at the prosecution side of things, how you get a trademark, and I think Azrul is going to talk more about what happens if you want to enforce it. And when we're talking about trademarks, what we're really talking about is brands. So there are four main types of intellectual property. We have patents for protecting concepts, trademarks for protecting brands, designs for protecting the appearance of things, and copyright for protecting the expression of works, whether that's literary, artistic, or musical or dramatic form. So this is my old phone, which really is quite old now. You could have a patent on the sliding mechanism. Samsung could well have we know has a trademark on it. You can have a registered design for the overall shape, and then copyright for the text in the manual. So you can have multiple different IP rights on one product. But really today, we're going to be talking about trademarks. The main reason for that is because the Trademarks Act 2019 came into force at the end of that year. And that's really it's a wholesale replacement of the previous act, which was 1976. So it's a fairly significant change. One of the things that's interesting about it is a lot of the details are more in line now with the UK and European laws. So for those of you who are familiar with that, actually Malaysia has now become much more straightforward, I think. Either Sven or Francesco mentioned earlier what a trademark now is. It's any sign capable of being represented graphically, which is capable of distinguishing goods or services of one undertaking from those of another. In other words, how is your brand different from other companies? That's really what that is saying. But we'll go into a bit more detail about how that can be interpreted on the following slides, because what can be considered a trademark has now been broadened considerably in Malaysia. In the past, it was been words and logos, but actually now we can have non-traditional marks as well, things like shapes and sounds, colors, and so on. And then when it comes to looking at whether something is registrable or not, they look at absolute and relative grounds. Now, these were sort of in the old Act anyway, but it's been renamed, shall we say. And this is, again, more consistent with what they say in Europe. If you are looking for a trademark, one of the things you want to make sure is that it's distinctive. Otherwise, you will get an absolute ground rejection. Distinctive means not descriptive of the goods or services. So if, for example, you were starting up a new burger bar, you don't try and have a brand called The Burger Bar because you'll automatically get a rejection. There are some exceptions to that rule, which is if it's become distinctive through you. So if you've called yourself something for so long that everyone now associates you with that particular set of words or word or image, then sometimes you can overcome that. But when you're first starting off with a new brand, then it's better to have something completely different. So, you know, elephant burgers or something would be a better idea, although perhaps on reflection that's not a good idea because it sounds like that might be deceptive. People might think you're selling elephants in your burgers, so that's probably not the best idea. But the general idea is that it should be distinctive, but also not offensive. So we don't want swear words usually, contrary to morality or national security. They don't like things like flags being in trademarks either. So there are a few limitations, but generally you're looking for something which does not relate to the things that you're trying to protect. When it comes to goods and services, there are currently 45 classes of goods and services. So, for example, clothing, all clothing is in class 25. When you submit your trademark, you choose the class of goods or services that you want, and then quite often you also specify the specific goods within that class. That's absolute grounds. When it comes to relative grounds, they also compare against, well, you know, are you going to conflict with anyone else? Is there an earlier trademark where if you trademark your brand, are you going to be confused with them? So, you know, again, if I opened McDougall's Burger Bar, I don't think McDonald's will be very happy about it. They'll probably sue me for trademark infringement. Azrul can tell you more about that later. But it's a same process when you're trying to apply in the first place. If you've got something too similar to what's already out there for the same sorts of goods, you're probably not going to get it registered in the first place. Trademarks can be renewed indefinitely for usually in 10-year periods. We'll see in a minute how long they can go on for. The other thing to bear in mind is people sometimes say, well, what's the difference between TM and the R in the circle? Well, the reason is because it takes a while sometimes to get a trademark registered, and you can use TM, or sometimes you can't get it registered for a while because it hasn't become distinctive enough. So you can use TM in the meantime. But once your trademark is registered, then you're entitled to use the R in the circle. One last point is in Malaysia, the registry changed their systems, IT systems, well, a few years ago now, but we are still having some difficulties with it. Some things don't quite work as well as they should. So if you do submit a trademark application in Malaysia, and then sometimes we get glitches, so just, you know, bear with us in the meantime. Let's look at some examples. These are all Malaysian trademarks. The numbers are there at the bottom. So you've got Nike, you've got Coca-Cola, which is probably worth 100 billion if you look at the total in the world. And Milkmaid is the oldest live trademark in Malaysia. It dates back to 1934. So they've been keeping it going, not just originally it was 14 years you had to renew it, but now it's 10 years, which is consistent with everyone else. So that's still going to this day. So it's nearly a century old now. So that just shows you you know, how long you can keep trademarks going. There are some other ones in the world which are older than that even. But for Malaysia, that's, you know, this is pre-independence. So that gives you an idea of the power a trademark can have. So let's look a little bit more at the definitions. Under the 1976 Act, well, I won't read it all out. You can see for yourselves there. It's a mark for distinguishing between one person's goods and another's. In the new Act, it says any sign capable of being represented graphically. Well, that's a little bit broader than a mark. It means you could have things which aren't just you know, words or logos, for example. And then it goes on to say, well, when we talk about sign, we mean these other things. So the things in red there are the main things that have changed. So not just words and logos now, we can also have shapes, colors, sounds, theoretically scents, and those other things. Let's have a look then at some additional examples and how what things might look like under the new Act. So these are the types of mark that you could register under the old Act, which is, of course, you can still register under the new Act. You can have word at marks, which just consist of, a plain word in a simple font. That's one of the broader types of protection because, and that's normally the one that is recommended if you can, because if you have a third party who is copying a similar mark, it doesn't matter what font they do it in, the plain font covers all. You're not limiting it in any way. Whereas if you look at the stylized words to the same, if someone came up with Secret Recipe or Coca-Cola, but it was a very distinctive and different font, maybe there's an argument to say that they don't infringe. Okay, realistically, probably not. But the point is the simpler form is a broader protection. You can have graphical marks, logos, which we call devices, or you could have a combination of those things, the combination marks there. But now what we can have is also things like shapes of their goods or their packaging. And when we submit this, we have to include a number of images. You can have up to 6 views in that. And you also have to have a description of saying, what actually it comprises of. So here's some examples here. You've got the ballpoint pens on the right, the different views, and you've got the cart door ice cream box. Now they gave these examples, and all the ones on the following slides are all from the Trademarks Manual. What's interesting is I don't think these would necessarily be registrable. They've given them as examples of what you should be doing in order to register them, but not the ones that the examples they've given aren't necessarily registrable themselves. So for example, if you look at this ballpoint pen, I wouldn't call that particularly distinctive. It looks like a normal ballpoint pen. I don't look at that ballpoint pen and think, oh, that must be associated with a famous brand name. So there could be a problem with the registrability of that particular trademark. On the other hand, cart door, because it's also got the brand name on it, well, that one's probably okay. I'm not quite sure why they would want to register that particular shape. I think maybe this is an embossed ice cream carton as well, or maybe it's got some extra ridging on it. I'm not really sure in this particular case, but because it's a bit like the combination before. The cart door bit is probably the distinctive bit in the overall shape of the trademark application. If you took away the cart door words, you probably wouldn't get this registered either. You wouldn't know that it was a cart door box. This is the point. You always want to, when you come to the non-traditional trademarks, you're really looking for a connection between what you see and the actual company. If you don't automatically think of the connection, you're probably not going to get it registered. Another example of this is the Toblerone. I think they actually got it rejected under the old Act, but when you think of Toblerone, when you think of the shape of the chocolate, those funny kind of pyramid triangle shapes, you probably would associate it with a brand. There's a fairly strong argument. Whether it would actually get registered or not, well, okay, that's another question. I think they didn't under the old Act, but they theoretically could have. They kind of extended it a little bit to say that shapes were perhaps registrable. What about colors then? So theoretically, you can register a color now as a brand. The one on the left here is Cadbury Purple. If you look at a milk chocolate bar in the UK that comes from Cadbury's, there's a specific type of purple that they always use. And they've registered that as a brand. So if you think of the color purple and chocolate, theoretically what they're saying is you should automatically think of Cadbury. Yeah, possibly. It's a fairly well-known color for Cadbury. They do get into fights with other people though about these sorts of things. I think Nestle is a bit of a competitor in this field. And in order to register these, you need an image, you need the Pantone code. The Pantone code is important because it's an internationally recognized system of color. So everywhere in the world will recognize what a Pantone code is. because if you didn't have the Pantone code, you probably know from experience, one person sees one type of purple, you take it to another person or you print it off and it comes out as a different type of purple. So the Pantone code is important to identify the specific shade, variation, tone, and so on of the color itself. So you need the image, a picture of the color, you need a Pantone code to describe what it is, but you also need a description of how it's applied as well. You'll see here, underneath it will say how it's applied to the packaging or the goods themselves. So that's how you would try and register a color. Most of the new applications under the Act, which are non-traditional so far, have been shapes and colors. There's quite a lot that have, I don't know how many have been granted yet, but most of the applications certainly have been in that field. There have also been a few for sounds as well, not as many. But again, sounds should be straightforward. You provide them with an MP3, the sound file itself, you give them a description, and according to the guidelines, you can also give them the musical notation. So the description here matches the musical notations, D, E, F sharp, E, D, A on a stave. What's interesting is that they say it's optional. I'm not sure why they say it's optional. I think you need it. It'd be very difficult to, well, I mean, not impossible, but it's a lot easier to represent it as a stave than it is in words. The one thing they do say is sonographs alone are not acceptable. We're not really sure what a sonograph is, but we think what they mean is this kind of waveform that I've shown there, which is, you can't really tell what that would sound like just by looking at it. I think if you're a musician, you could probably hum the tune of the other two. You could hum it from the description, you could hum it from the musical states, but you really can't identify it from that kind of waveform that's depicted at the bottom of the screen there. So there've been a few of those, but then you get some more interesting ones like scent. So how would you, theoretically, you can now register a smell of a trademark as a trademark. And the examples they give you is things like freshly cut grass for tennis balls, or the smell of roses applied to car tires. So when you think of these smells, apparently you're supposed to think of a particular brand. But how do you represent that graphically? Well, one way they say is to give them the chemical composition, this methylcinnamate there, or the scent of balsamically fruity with a slight hint of cinnamon. But of course, one of the issues with this is what smells fruity to me might not smell fruity to you, or cinnamon, I might be defective in my cinnamon receptor, so I might not be able to smell it as well as someone else. And this is, I think, the issue with scent trademarks. I don't think anyone's applied for one yet because everyone's waiting to see actually how this will work in practice. And it's a very difficult one because there isn't really an international standard for scents or smells. And what happened in Europe was actually in connection with an earlier trademark, and they said, well, you can't easily clearly describe the smells so that someone can understand it from looking at your description, at least not precisely enough. And this was the Siekman case, which led to the Siekman criteria for future reference, saying this is what you have to this is the standard you have to meet in order to register a trademark. And I think that the general issue with smells in particular is intelligibility. Can you really understand precisely what a smell smells like if you're just given a written description? Or is there a way of doing it on an international standard? At the moment, I think that's still no. So what we're not sure about at the moment is whether Malaysia will accept, this kind of word version, or are they going to apply the higher standard of, the Siekman criteria, in which case pretty much anything would fail at the moment. We don't know. We have asked the question to the registry and they've not really given us any information in return. So that one's still a bit unknown. So like I say, theoretically possible, in practice, maybe not at the moment. Things may change in the future. We'll just have to wait and see. What else do we have? Okay, so holograms is another one. Again, this is a bit more straightforward. It's a bit new, but it should be okay because you just submit the graphic or the photographic reproduction, up to 6 views from the different directions. Again, you want a written description, you can see some examples at the bottom here. You can also submit a video as well. So you can show how the trademark, what it looks like from different angles by just, filming around it. I don't think many people have applied for this yet. I suspect this, you'll get things with credit cards or something like that, the people that produce holograms at some point, but it's a fairly new thing and it's not the easiest way to submit a trademark. So they'll come out, I expect, in due course, but there aren't many applications at the moment. We can also have positioning marks. So this is where you have some kind of logo or graphic in relation to something on a particular good. So you can see on the bottom of a shoe here, there's an orange circle with a shape. On the bottle, we've got a figure of a man carrying a barrel on the bottom of the bottle. And then you disregard the rest of it. We're not interested in the bottom of the shoes, so you disregard it by putting the rest in dotted lines. So that's how you'd apply for a positioning mark. Again, these are not so popular, but the availability is there. And then one of the last ones is graphical marks. I think these will become more popular just because of how people are using memes these days and the availability of TikTok and so on. Again, you can do it in a few different ways. Normally you want a graphic representation with a series of stills, the frames of the video. You also must have a description, but more importantly, while it says you can also submit video, I think actually it's quite important that you should in this particular case, because that's really what you're trying to protect. So you can see this cart opening or a series of the images in the bowls here. These, I think, will become more popular over time. So just going back to what you need for a trademark application. Okay, so the owner's name and address. One thing that's changed is if you're based in Malaysia, you need to include the company number or your IC. You don't need that for foreign applicants, but Malaysian, it's a requirement because of the way the IP, the online system works. You need to know what type of trademark it is. Is it a normal trademark? Is it a collective mark or certification mark? I'll mention those in a minute. What type of trademark is it in terms of its nature? Is it a traditional one, word, graphic, or so on? Or is it one of the newer non-traditional types? Is it a sound or a scent or something like that? Then, of course, you need the graphical representation of the mark. You need to actually fill this in the form. You need to specify classes. And this is one thing that's extra that's improved. In the old days, we used to just have one class that we could submit per trademark. Now it's multiple classes. But having said that, they haven't reduced the filing fees at all. So it's worked out as the filing and the renewal fees are per class. So it doesn't actually save you any, well, it maybe saves you a little bit, but doesn't save you much money to do it all in one go. Maybe it will help on the admin side if you want to manage, multiple classes altogether. But the problem is if you get objections to one class in your group, it might delay the other, unless you, of course, file a divisional application, but then then you're getting extra costs. So whether or not multiple classes is actually that useful remains to be seen. I think a lot of people are still using single classes just to keep things a bit more straightforward. You also need to list the goods and services that you want for each class. This is where it can make a difference, because if they are standard goods or services, it probably means they'll be on the pre-approved list. So MyPro, the registry has a list of goods which they've already endorsed as acceptable. And it matches the international classifications, the NIS guide. And if they're on that list, then it reduces your official fees a little bit. Not much, but yeah, everything helps. Then if you've got a priority claim to an earlier application, you put this in here as well. And if you've got any non-standard fonts, so if it's a foreign word or a Chinese script, then you also have to put in the translations and the transliterations at this point, as it says on the screen. Right, I think I'm starting to run out of time, so I don't think we've got too many more though. One of the major changes under the new Act is that we are now part of the Madrid Protocol. And this allows you to file an international trademark application. And the way this works is you submit your Malaysian application, or rather your home application, wherever you're based first, preferably also get it registered. We'll come to why in a minute. And once you've got that sorted out, you can also you can apply for the Madrid application and designate other member countries. There's more than 120 countries now in the Madrid system. And it lets you designate the countries, and then if no objections are raised within the specified period, normally 18 months, then it becomes registered in those other countries as well. So the main good thing about this is it means if you've got a lot of countries, it can be centrally administered, whether that's for assignments or other transfers, whether it's being renewals or of the trademarks or so on. The problem is if you lose your home trademark, if there's objections to the home trademark, it ripples out to the others. And you then have to kind of split it up into national trademarks, and it can actually cause problems. So these are not insurmountable problems, but it's just a bit, it can make life a bit more difficult. So it depends, to some extent, it depends on how solid your trademark is in the first place, which is why it's best to get it registered first, not just the application. But also how many countries you're interested in. Now, if we look at the next slide, I think this is roughly, this is where we are at the moment with the number of Madrid members. And you'll see it covers most of the developed world, quite a lot of the developing world, and really the exclusions are in South America, Middle East, and Africa, which is not unusual, I think, for IP. But you know, most of the countries, most of the major countries are all in there now. I think Brazil is one that's joined recently, and because of that, we'll probably see a bit of a spread now for South America because of the Spanish connection and Portuguese connection. So just to summarize, on the left, you'll see the Trademarks Act, the old Trademarks Act, on the right is the new. So on the old Trademarks Act, just word and images, Trademarks Act new, for 2019, we now have these additional things. Single classes only under the old Act. Now we can do multiple classes. One of the things that's changed is under the old Act, if you claimed priority that your initial 10-year term ran from the priority date, whereas now it runs from the filing date, irrespective of priority date. That's more in line with international standards in the new Act. Of course, we've joined Madrid, as we've just said, and we also now have collective marks. So when it comes to certification marks, which were available under the old Act, we're talking about if you're a member, you can have a mark to certify that goods or services meet certain standards. In addition to that, we can now have collective marks to say, you know, if you belong to an association, you can have a trademark saying that you are a member of that association. So that can be useful for certain organizations. Under the old Act, we also need a statutory declaration to say that the mark was in use. That's no longer required, which is a good thing because it speeds things up. But on the downside, under the old Act, if objections were raised to your trademark application and it was refused, you could appeal internally to the trademark registry. Well, now, if that happens, we can only appeal to court. So in some ways that's become more difficult because we only get one shot at overcoming the objections, and if it goes wrong, we have to go to court over it. So it's going to be, I think that's going to become more expensive for people if we run into difficulties. So I think that's all I have to say for now. I guess there's going to be some questions and answers later, so I'll pass back to Dada now and let her move on to the next person. Okay, thanks.
Okay, thank you, Dr. Chris, for the very insightful information indeed on different areas about Malaysia IP trademark examples and trademark acts. Let us now move on to our next expert speaker, Encik Azrul Abdul Hamid, partner for Azrul, Liew & Co. Encik Azrul has gained more than 20 years of litigation experience dealing in a wide range of litigious matters at the High Court and the appeal courts involving intellectual property claims, including inter alia, patent, trademark, copyright, trade secret, passing off, and trade libel. Encik Azrul also deals with many tortious claims such as unlawful interference with trade and negligence claims. Other matters that Azrul deals in include debt collection, breach of contract, and also provide advisory services for the retail, tenancy, and hospitality industry, providing corporate advisory services, industrial relations queries, and also drafting and vetting agreements. And he has advised clients on the multiple facets of public policy and government engagement, including dealing with government agencies and local authorities in relation to business-related issues for startups, SMEs, and MNCs. Throughout the years, Encik Azrul has worked closely with many government agencies and especially the Ministry of Domestic Trade and Consumer Affairs, our beloved ministry, KPD and HEP, in joint efforts to eradicate piracy and counterfeiting in Malaysia. He's also a member of the Cyber Law Committee of the Malaysian Bar, and another impressive background there about our speaker today, and who is also a great supporter of our IPR working group at the Chamber. So, Encik Azrul, the floor is yours now.
Thank you. That was quite a mouthful. Thanks for the intro. Okay, I'm going just following on from Dr. Chris's talk just now. I'm going to be talking about what happens when you have
Azrul, yes? Sorry to interrupt. Can you change the? I think the slides are not on the presentation mode, or is it?
Is it?
It's not.
Sorry,
because,
you can go to
sorry, Azrul, are you using two screens? If yes, you may remove one screen because this happens sometimes.
Oh, okay.
We use two screens.
Move
yeah.
one screen.
Yeah.
Yeah. Sorry, Azrul.
No.
Is that better?
No.
Wait,
okay, maybe.
Can you please unshare and then share again, please?
Yeah. Is that okay?
Yes.
Yes.
Okay, thank you.
Thank
Sorry
you.
for that. Okay. Okay. I'm just going to talk a bit about the Southeast Asia IP SME Help Desk. The Southeast Asia IP SME Help Desk is an initiative of the European Commission to help European small and medium-sized enterprises to protect and enforce their IPR, intellectual property rights, in relation to Southeast Asia. All services provided by the help desk are free of charge, so that's a good thing, for EU SMEs and intermediaries. On this slide, you can see the range of services offered by the help desk. The first one on the left, the top left, is the inquiry helpline. Through the inquiry helpline, you can send any IP questions related to Southeast Asia to the help desk, and you will receive a reply within 3 working days. So the help desk has external experts within all the different Southeast Asian countries. So these questions will go to the experts and they will assist you to answer the questions. Secondly, the help desk organizes monthly training workshops and live webinars such as this one, which is tailored to the needs of SMEs across Europe and Southeast Asia throughout the year. We have had many webinars this year already, and please feel free to subscribe to our newsletter and connect with the team on social media to keep yourself updated on the upcoming activities. The help desk website, as you can see, which is at the bottom middle here, gives you access to a wide range of publications in terms of country fact sheets. These are very helpful because it provides you with an overview of the IP laws within each country, like what rights would you have and how it can be protected within these countries. Industry-specific IP guides or general IP guides on various IP topics. These guides can be easily found on the help desk website. Last but not least, The help desk also offers interactive learning tools, for example, e-learning modules, which is also available for download from the official website. Okay, thank you. I'll skip my bio. So we would like to just have a poll before we start off with this presentation. In case of trademark infringement in Malaysia, I would be able to enforce my right only if my trademark is registered. So perhaps the attendees can give their input in the polls as to whether this is true or false. And the second poll is, in Malaysia, criminal enforcement is available for patents and industrial designs. Is this true or false in Malaysia? Thank you. Okay. So the agenda today is I'm going to talk about, Chris was talking about how you protect your trademark by way of filing your trademark applications in Malaysia, and you get a trademark registration in Malaysia. Okay, so as a trademark owner, you have that in hand. So what is it that you can now do if somebody comes forward, a third party, your competitor comes forward and infringes your right? So I'm going to talk about what is an infringement under the new Trademarks Act, the elements of trademark infringement, what is passing off, is this relevant to your trademark, the common defenses, and the second part is how you enforce these rights for purposes of a civil action and a criminal action. Okay, for civil infringement, this is in relation to trademark infringement pursuant to the Trademarks Act 2019. It is indicated that it is an infringement if you do not obtain the consent of the owner of the mark in the course of trade. In the course of trade is important. That means that in the normal course of your business, a sign which, as Dr. Chris has indicated just now, encompasses many things like your word mark, your brands. It can now also be your sense. It can now also be the sound that is identical to the registered trademark in relation to the goods or services similar to those for which the trademark is registered. And it is also in relation to a similar trademark that is used in relation to goods or services identical with or similar to those which the trademark is registered. And as a consequence thereof, it causes a likelihood of confusion on the part of the public. So this is a fairly slightly different departure from trademark infringement previously. Previously, it has to be trademark infringement of an identical mark or something which is can cause confusion to the trade and public in relation to the mark that you registered in a particular class. Say, for example, you register your mark for clothes and the infringement is not in relation to clothes, then it will not be in trademark infringement if you look at the old act. But if you look at the new act, it does appear to indicate that when it comes to trademark infringement, the idea is now expanded. The infringement is not only to the particular class of goods or services that you have, but it also seems to indicate that it is also for a similar class of goods that you have registered your trademark under. So this is a fairly slight departure from the old act. So in the old, sorry. Okay, so in the old act, it was a registered proprietor. It is that the defendant is neither the registered proprietor nor the registered user of the trademark, and the offending mark is identical or so nearly resembling. So the wording or the standard now is slightly different. Previously, is something which is so nearly resembling. Now it is something which is similar to the infringing mark. Okay, so what is it that you can do when you file an action in relation to a trademark infringement? In usual cases, in usual intellectual property cases, this goes also for cases such as patent infringement or copyright infringement. The first relief that you would like to seek from the court is an injunction. You want the person who is using the infringing mark to stop using that infringing mark. The reason is various. I mean, the first reason is, of course, you do not want that person to be using your trademark without your permission. So he is perpetually, you would ask for an injunction in perpetuity. Basically, the person cannot use that particular trademark forever without your permission. And secondly, by having this injunction, you do not want your trademark to be diluted where it is used by an infringing party. So you are preventing a person who does not have your consent to use your trademark. So this goes also with copyright infringement or also patent infringement. You do not want third parties that to unlawfully be writing onto your good name, onto your trademark without your permission. And of course, secondly, you want damages. You want the infringing party to pay you for the profits that they obtain from the use of your trademark. And this can be in the form of an account of profits, or it can be in the form of general damages, where it is usually quantified by way of ascertaining the value of your trademark and how that person who has used your trademark should pay for using that trademark without your permission. So in the recent cases that we have, it is very difficult to prove general damages vis-a-vis the reputation or the value of your trademark. So it is usually up to the brand owner, the lawyers, to try and assist the court in determining this particular figure. So it's not something which is fairly straightforward, but this is something that is new in the new Trademarks Act. Previously, we do not have a statutory explicit terms in relation to what is it that you can claim from the court. But now the Act provides that it is provided statutorily that injunction is supposed to be provided for. You can claim for damages, you can claim for an account of profits, and you can also ask for additional damages if the court deems appropriate. Some examples of additional damages is like aggravated damages, and this would usually apply in cases where the infringing party is a counterfeiter. I propose that, for cases of blatant or rampant counterfeiting, you should always ask for aggravated damages against the defendant. So the new Act also provides for additional statutory relief. Before in the old Act, most of the relief that we pray for, the legal jargon as it were, or that we ask from the court, is something that is we find in the common law, from the English cases, Australian cases, etc., Indian cases. So this is where we usually find cases to persuade the courts here to provide us with the relief that we ask in relation to a case of trademark infringement or a passing off case. So now in the new Act, the courts, the Malaysian legislation has also provided for statutory relief, where besides just looking through the common law principles, we are also be given the statutory option to also ask for court order for an erasure or the taking down of the offending sign. I believe this in relation to the use of a signage, where the signage is for purposes of an infringing service or for purposes of an infringing product. So you can ask for an order for the infringing party to take down the sign and for it to be destroyed. And of course, the delivery of the infringing goods, materials, or articles. And once we obtain a judgment against the defendant, we don't want them to just keep the infringing product. We want them to be to them to deliver up the infringing product. And the third statutory relief is also for the disposal or for the infringing product to be destroyed properly, instead of we sue the infringing party and we get a judgment, and what he does is he distributes it into the market, which would then be difficult for us to go after all the various parties that are involved in the receipt of this infringing product. Okay, so on the other side of the coin, we have cases of trademark infringement, but there may be also circumstances where we feel that we are at the receiving end of an infringing suit. So some of the things that we would raise when it comes to defending a claim of trademark infringement is that our use has been in good faith. Perhaps our use has been in parallel with the registered trademark for a substantial amount of time, and we have achieved some form of distinctiveness. Secondly, if you remember that in cases of infringement, the mark has to be identical or similar to the registered trademark. So a defense that we would usually raise is when it comes to cases where the mark, although is similar, but it can be distinguished, and therefore we would use that as a defense. And because we are able to distinguish, or we can show a difference between the registered trademark and also the alleged infringing trademark, it does not cause confusion to the trade and public. So this is what one of the point of attacks that we would have when it comes to defending a case of a trademark infringement. And of course, there are other ways of defending, such as if it has been used in good faith. There are some cases where we have obtained a license or consent, but that was not disclosed by the proprietor of the trademark, or we have been the first user of the trademark in Malaysia. In Malaysia, as opposed to jurisdiction like China, for example, we operate on the principle that the first user defeats the first registration or the first applicant of the mark. Whereas in places like China, it is the first registered proprietor as opposed to the first user. And fourthly, what is very useful when it comes to cases of trademark infringement, where you find that the suit filed against you may not be within reasonable grounds, and perhaps the trademark should not have been registered in Malaysia, or the trademark would have not been used in Malaysia. So as a point of counter-attack, we would propose to invalidate the trademark for non-use. I mean, if in Malaysia, if you do not use the mark, there are cases when you just file a mark to prepare yourself to enter into the jurisdiction, and marketing plans may take quite some time. But if you start to if your mark is registered and you have not used your mark for more than 3 years from the date of registration, you are open to an invalidation of your trademark for non-use. So this is something that you would have to be careful when you are making your application for a registered mark in Malaysia. It is still provided for in the new Trademarks Act that if you do not use your trademark, this can be used against you when it comes to proceedings of trademark infringement, or when it comes to matters where you have you file a trademark in Malaysia, and then you find that there has been prior registrants or prior applicants to the mark. There may be a good option to perhaps investigate whether these marks are used in Malaysia or not. Yeah. Okay. So the second option when it comes to protecting your trademarks in Malaysia is this common law principle of passing out. So when it comes to the statutory provisions for trademark infringement, it is provided for under the Trademarks Act 2019. But in Malaysia, we also have an option for brand owners who do not have a trademark registration in Malaysia to also have a cause of action of passing off if you can show the conditions as provided for in case law in Malaysia. Firstly, you have to show that the use of your trademark by another person has caused misrepresentation. For example, the use of your trademark has caused other people to be confused that third party is using a mark where in fact it belongs to you. Okay, and this has to be in the course of trade. It has to be in the course of business. And secondly, the use is caused to injure the business or goodwill of your business. So what this means is that in order to make a claim of passing off, you have to prove to the court that the particular trademark that you have substantial goodwill and reputation in that particular trademark. So how do you show this? You show this by way of showing that you have made like tons of money from the sale of that particular trademark in Malaysia and worldwide, that this mark is actually has substantial goodwill and reputation. It's just that you do not have a registration of the same in Malaysia, and as such, you cannot proceed with a case of trademark infringement. But that does not mean that you do not have a case. You have the option in Malaysia. You have the option of also having a cause of action of what they call passing off. And if you can prove these four principles, it would be taken that as a result thereof, you have suffered damages to your business. Okay, so how do you defend this? It is similar to a defense when it comes to a case of trademark infringement. But the first thing that you, as a defendant, where somebody has made a claim of passing off against you, you try to dispute that whether they do have the requisite goodwill and reputation in the particular trademark or not. So this comes by way of evidence. You can show that you actually have more goodwill and reputation in that particular mark. You can show perhaps their business is not doing so well, and as such there is no goodwill and reputation in that particular mark. Secondly, there have been cases, again, I raised this point, there have been cases where the trademark owner may have consented to the use of the mark by way of conduct or by way of documentary evidence. And thirdly, that you both have concurrent rights, and this may be in cases where the mark are fairly similar, but each party have their own distinctiveness in their particular trademark, and you should raise this as a defense when it comes to cases of passing off. And there has also been cases where the plaintiff's mark has ceased to have substantial goodwill and reputation, or the distinct, like Dr. Chris was mentioning, the main thing, the most important thing when it comes to a trademark is it has to be distinctive. It has to belong to you and nobody else. And there has been cases where the trademark has lost its distinctiveness. And in this case, you can argue against the claim of a trademark in passing off, where you say that there is no more distinctiveness, and as such, there is no goodwill and reputation subsisting in that particular trademark. And also you can raise the most important point in Malaysia is that there is no misrepresentation at all when it comes to comparing the two trademarks. In Malaysia, we have this quite famous case. It's the case of McDonald's versus this restaurant called McCurry. And in this case, the court has decided that there is no confusion between McDonald's and McCurry. It's a very famous case. If you Google it, you're going to find it straight away. So because McCurry, people wouldn't think that it would be something that would come from McDonald's, but and such, it has obtained its own distinctiveness. And because of that, the court found that there is no likelihood that the public would be confused. Okay, so again, like the case of trademark infringement, what are the reliefs that you would want? When it comes to a case of passing off, it's fairly the same thing. You would have even in the case of trademark infringement, you would get the court to declare that you have rights over the trademark. Of course, you will ask for damages and accounts of profits. You ask for an injunction. You ask for the delivery up of the infringing products. You ask for discovery of information, and maybe even for the defendant to publish a notice in the papers to apologize for the infringing actions. Okay, now I go to the second part of the enforcement of your trademark rights in Malaysia. So just now I was talking about the civil part of protecting your rights in Malaysia. Now I will be talking about the criminal or the quasi-criminal part of protection of trademarks in Malaysia. So I try to hurry a bit because I think we don't have much time. So in Malaysia, it is expressly provided for in the Act, in the Trademarks Act. Previously, it was provided for in this Act called the Trade. Okay, yeah, I'll wrap up quickly. So I will just go quickly about the enforcement of rights. So basically, in Malaysia, you have if you have counterfeiting issues, you can make a complaint to the Ministry of Domestic Trade and Consumer Affairs. And if you have a registered trademark, you bring your trademark registration certificate with you to the Ministry of Domestic Trade of Trademark Trade and Consumer Affairs, and you make a complaint for the ministry officers to go out and take action against counterfeiters of your trademark. You know, we have quite a substantial, a lot of places where you can find these infringing acts. So what the MDTCA does is that they govern the Copyright Act and the Trademarks Act. So if anything, when it comes to infringement of copyright or trademark, you can make a complaint to the MDTCA. You file a complaint, you go for the rate action, they seize your goods, and then the infringer will either be prosecuted in court or be made to pay a fine. So in Malaysia, we do not have the same provisions for the Patent and Industrial Design Acts. So those are only pursuant to the civil laws. And besides, who else you can complain to? If you find that there's a lot of issues of online infringement, you can complain to the MCMC, the Communications and Multimedia Commission. For copyright cases, you can also complain to the Royal Police. And of course, when it comes to border measures, you would want to engage the Royal Malaysian Customs and Excise. So that's basically my presentation. Thank you. So please let me know if you have any questions. I'm sorry I had to hurry up the last part. I think I have to cut our time when it comes to the civil matters. Yeah.
Yes, we don't have much time, Azrul, but thank you for the sharing session and the very comprehensive presentation about all the trademarks inputs and overviews. So I will ask, maybe I'm allowed to ask maybe just one question. What kind of damages in monetary terms would a brand owner be likely to obtain in relation to cases of trademark infringement?
Yeah. So when it comes to trademark infringement, you're going to look at how much, what is the profit margin of the infringer. So that is something that you would have to assess after you get your judgment. So you have to quantify, both parties would have to disclose their accounts, I mean the infringer, and from that you would have to quantify how much did they gain from selling those products that bear the infringing trademark. Of course, you should also ask for aggravated damages. You should ask for general damages for damaging your trademark, and this may come up to about a few $100,000 as well. Yeah, so you're looking at what the defendant gained from the sale of the content products, and also you want to ask for general damages.
Okay, thank you. I believe that I've already gotten some cues to wrap up the session, gentlemen, Dr. Chris and Mr. Azrul, but we can always continue this discussion. Perhaps we will plan for a serial webinar for this topic. I'm not sure, we have to discuss with the team. Okay, so before we go, any comments from Dr. Chris or Azrul just a 1-minute comment before we close the webinar.
I'm good. I was just going to say the Patents Act has also just been updated, so maybe that's a possible future topic.
Okay, wonderful. We'll take note of that, Dr. Chris. And Azrul?
Yeah. I think it's a good thing that we have this new Trademark Act. It's a departure from the old act, as you were. I think Chris will know this very well as well. We have come from the traditional trademarks to the non-traditional trademarks. It's something which the world has a lot more of these days. So I think it's good for Malaysia as well, for protecting the rights of the trademark owners. Yes.
Right. Wonderful. So I believe we will end the session here due to time constraint. It was a fruitful discussion indeed, of the Q&A session. We only had one question, but we will continue with another session soon. Okay. So thank you for the very informative and interactive session in providing more in-depth and clarity on our topic today, new trademark updates in Malaysia. And to Dr. Chris, Hemingway, and Azrul Hamid, thank you again for making the time and for both of your commitment to be here at this webinar today, and also to our supporting team members behind the scenes here from Southeast Asia IP SME Helpdesk and EU Delegation to Malaysia. Also to my colleagues at the Chamber, who has been a great technical and coordination support during the whole session. And ladies and gentlemen, on behalf of EuroCham Malaysia, I would like to thank our corporate partners, members on board, B. Brown, Futurize, Ericsson, Unilin, Siemens, and strategic healthcare partner, Malaysia Healthcare Travel Council, MHTC, our supporting partner, Malaysian Investment Development Authority, MIDA, and as well as our technology partner, Liew. We hope that you have gained great takeaways from the briefing session today, sharing session, I mean. I believe that our next webinar will be held as quickly in the next coming weeks, and we will keep everyone informed all across our media platforms at the Chamber. Please remain safe during this endemic period, to always comply with the government SOPs, check your health status regularly, and make sure to wear your mask and in crowded places. To all Muslims, we wish you all blessed Ramadan Kareem and selamat berbuka puasa for later. With that, I thank you. Thank you, Dr. Chris, and thanks, Azrul.
Thank you.
Thank you, Sven. Thank you.